So, Stuart, let's talk a little bit about signing the case. What are some of the components? What are some of the things that we need to know in order to do it effectively?
First of all, it's always an honor and a privilege to get called to meet a client to sign up a case. And you need to feel that way because you're up at the plate and you're swinging. And that's, as a personal injury lawyer, that's where you want to be. If you hear about a prominent case on the news and you say, wow, I wish I had that case, you want to get in front of that client and be able to talk to them and sell yourself and sell your firm. And the way to do that is with class and dignity. You need to have certain things in place in order to have that class and dignity, which clients will look at and say, this is the kind of lawyer, this is the kind of firm I want to represent me. So you need to present yourself well. You need to have professionally done business cards. If you could have a logo, that's great. Your website should be professionally done. A firm brochure is a very nice thing to hand a client. And the firm brochure should really have a mission statement. Talk about what your beliefs are about your firm and about what your service requirements are to your client. It should give biographies of the lawyers in the firm. Talk about them not only professionally, but somewhat personally, and what their beliefs are and why they got involved in handling personal injury cases. It's important to be qualified. And if you haven't practiced long enough to be rated by Martindale-Hubbell, there's other ways to be qualified. For example, you should be a member of the state associations for trial lawyers, the American Justice Association. You should be involved in as many committees as you could be. You should go ahead and, if you could be board certified in civil trial work, if your state has that, become board certified, so that you present yourself in such a way that, from a documentation standpoint, somebody looks at you and judges you against another firm, you've got all the right qualifications. And if you haven't gotten those, work towards those. Learn what you need to do to get board certified, what you need to do to get AV rated, what you need to do to join the associations for trial lawyers and become part of it. You also want to talk about in your website or in your brochures your experience with the types of cases that you're going to be handling. And you have to remember, we're in a society where people are used to watching legal shows which last an hour, and they go from the beginning of the case to the end of the case. So people today are used to getting information quickly, making a decision quickly. So you don't want to hit them with anything long, anything complicated. You want to hit them with a couple of lines, a couple of facts, and let them choose and see who you are. Dress appropriately, dress professionally, be well groomed. All that's important. And know how to speak to a client. If your client speaks a foreign language, if you have someone in your office that speaks that language, have them accompany you. If you're dealing with a very sensitive case involving the death of a loved one or an injury to a child, you may have a particular staff member who is very warm, very cuddly, very friendly, and I'll have that person come with me to sign up a case sometimes, sit in with me, because sometimes two-on-one, where someone is being warm and being friendly and being solicitous of the potential client is really important. You want to make them feel comfortable. You want to offer them coffee. You want to tell them you understand how hard this is for them. You want to bring yourself in as a real person. You don't want to distance yourself from their pain, from their problems. You want to let them know that you understand what they're going to go through and what they are going through. And that all helps tremendously in signing up a case. And there is no greater feeling initially than signing up a case, because it means you presented yourself well, you're a success, and that's when your work begins. Once you've signed up the case. But it takes a lot of effort. It's not something that you should do haphazard. You should really talk, when you talk to the client, see if it's easier for them to come to the office. Because if you're proud of your office and you want them to see them, It gives them some self-confidence that you're a successful lawyer. If you go to their home, you go to the hospital, try to make sure that they make it to your office in the first month or so that they see that you're a real operation, that you have significant resources, that there are people working on their cases, that your file cabinets are full of cases that show that you're working hard for them. Show them their file every once in a while. Show them how organized it is. And answer their questions, because when you're organized and when they see that you know the answers, they're more confident and they're more comfortable with you.
And some attorneys send out investigators or associates from their office to sign up the case. What are some of the pros and cons, in your opinion, of doing it that way?
Well, people like to deal with the lawyer that's going to be representing them. At times it's not possible. At times I'll be in trial, I'll be out of town, my associate will go out, my partner will go out, our investigator will go out. But as soon as I can, I try to set up a meeting with those clients. Whether I go to them, they come to me, so they understand that I'll be there supervising or actually working hands-on on their case. If a client's in a meeting in my office with another attorney, I'll go in there and pop my head in and say hello and sit down and talk to them for a few minutes. Let them know that I care. And that's very, very important. Clients want to know that if you are a firm, if there's more than one lawyer, who's going to be working on their file? Who's going to be overseeing their file? Is the person that they came to a law firm because of going to be responsible for their file? That's why we conduct monthly and bi-monthly meetings to review every case. And if there's a problem with a client or a problem with a case, I'll make sure that I'm part of that conversation with the client, so that it's not only coming from an associate, it's not coming from a paralegal, it's coming from me.
Great. So let's talk a little bit about you talked about some of the different bar associations, some of the different certifications. Let's talk about experience with the different types of cases. Knowing that you're comfortable with the type of case, you can afford to handle it. You spoke a little bit about that, but if you can go a little more in depth, that would be great.
Sure. Every type of case has different nuances. There are little intricacies in the law. There are tricks that you learn, or hopefully will learn over the years. These are all ways to increase the value of the case. And these are things that you need to look at and talk about with your staff from the moment you sign up the case. We all want to find liability. We want to find coverage. We want to find damages if they're there. But you have to know where to look. You've got to learn how to ask the right questions. For example, if there's a car accident, was the person in the course and scope of their employment at the time? What other insurance coverages might be available other than the coverage of the driver? Is there a separate driver and owner? Was the car rented? Was it leased? What uninsured motorist policies exist in the household of your client? Who did your client reside with? These are all questions in automobile cases which come into play.
And obviously they're going to be based on the different state rules where the attorneys are practicing it.
Absolutely. And you have to know the rules and the laws of your state. If a client comes to me and says, I was injured in an accident in Oklahoma, and it's a bad accident, I will immediately contact another qualified lawyer in Oklahoma, co-counsel a case with them if they're client, and do what I can from my standpoint, from a medical standpoint, from an expert standpoint, but I don't want to go ahead and think that I can learn all the nuances of Oklahoma personal injury law in a 5 or 10 minute review or even a 2 or 3 day review. It's too complicated. And I respect my clients too much not to give them the benefit of having the best representation possible. So you need to understand all the nuances. If you're in no-fault state, you need to understand how the no-fault law works. Is a motorcycle a motor vehicle or not? Is a golf cart a motor vehicle or not? What happens to a pedestrian who's hit? Whose insurance pays their medical bills? Things of that nature. These are all things that seem, when somebody walks in the door with an accident case, simple, but they're not. And malpractice cases, product liability cases are even more complicated. Premises liability cases. Because you've got owners of property, you've got managers of property, you've got lessors, you've got lessees. You've got all sorts of situations, and you have to understand how these all come into play with one another, and who's ultimately responsible for your client's injuries.
Well, that's great. So let's also talk about some of the turn downs you spoke to when you go sign up a case. Some dealings with bad feeling about the client or the cause of action. Different experiences that you have, and if you can give us some examples of some times when you've gone to go sign up a case and realized this was not one of those cases you wanted to take on.
One of the first things you want to do as a trial lawyer is you want to develop a gut. And if your gut instinct tells you that this client's a problem, that this case is a problem, that you're going to be spending an inordinate amount of time and money for a result that won't justify it, don't take the case. You're doing yourself a favor, you're doing the client a favor by just saying up front, I'm very sorry for what happened, but this is not a case that my firm's comfortable in handling. We're not equipped to handle it. Even if we were to win, and I'll tell clients this, let me give you an example. Out of 100 malpractice inquiries that my firm gets, we may accept 3 or 4. And you may say, wow, that's a very low number. But you have to understand the economics and the law of medical malpractice. Medical malpractice cases are very, very expensive. They're very time-consuming. They're very resource-intensive. You have to spend tens of thousands or hundreds of thousands of dollars on a malpractice case in order to get a good result. So one of the first things you're going to look at is damages. Is the person hurt badly enough to justify a 6-figure plus award? And in my firm, we have a policy where unless the case is worth a minimum in our estimation of $250,000, we just won't handle a medical malpractice case. Because by the time you figure in your overhead, your costs, the liens on the case, the client's going to walk away with nothing, and you're going to have an unhappy client. So even if you're successful, you're not successful. And I'll often tell clients, I'm very sorry, I think you've got a claim, but economically, it's not a viable claim. And maybe you should contact the doctor, maybe you should try to do something yourself, or contact another lawyer. And I put this in letters to clients that I turn down their cases. I regretfully turn it down. I explain to them what their rights are. I explain to them the statute of limitations. And I implore them to please go speak to another qualified lawyer to run the case by them, because, as I put it, like with many things in life, someone else may see this case differently and may want to run with it. I have certainly turned down a few cases in my life where I'm sure people went on to successful conclusions. I've also gotten cases other lawyers have turned down, and I've turned them into gold. So we're not all perfect, we're not all right. Just be careful. And if you do turn down a case that turns out right, don't get crazy and start taking every case that comes in the door. We all make mistakes. But you're better off erring on the side of caution, because if you don't, a case that could bankrupt you could just ruin your whole life in your home practice.
Well, you're obviously very successful and have had some outstanding experiences. But why don't you share with us one of your war stories? Because I'm sure that out there there's some attorneys that feel that they're the only ones who've had something horrible happen when they've taken on a case. And we know that in the past that you might have had something like that.
Sure. I mean, we've all had that happen. I had a case I'll never forget involving a young man who came into my office every time to see me using a cane. And he had sustained a very serious leg injury from what was explained to me by the doctor. And he claimed he couldn't do certain things in life. One of those things was changing tires at his dad's gas station. And you could be sure as could be that they had surveillance of him, which they showed me, of him changing a heavy truck tire. No cane in sight, no limp in sight or anything like that. And when I showed it to him, he says, well, that's not me. That's a guy that looks like me who works at the station. I said, well, bring him in. Well, my client was 5'4". The guy who brought in was 6'2". There was no way that anybody could go ahead and mistake the two of them for being the same person. And we lost a lot of money on that case because we had invested a lot of money on that case. I'm also very cautious to avoid situations like that. And what I tell clients is two things. You never say never, and you never say always. And let me explain what I mean by that. I said, I'll tell them, for example, let's say they have a back injury, and they're asked the question, well, what can't you do as a result of your back injury? And they'll go through a litany of things, and I'll in advance have the clients make up a list of things they can't do at all and things that they are limited in doing, and I'll explain the difference to them. And the defense lawyer will say, well, can you lift groceries out of your trunk and carry them into the house? And I'll tell a client this example. I'll say, if you say, no, I've never been able to do that since the accident, you could be sure that they have a surveillance photo of you carrying a grocery bag. And that grocery bag may have a box of Kleenex tissues in it, which weighs nothing. But all the jury is going to see is you carrying a bag and you having said, no, I've never done it. So you never say never, and you never say always. What I advise clients to do from day one when doctors ask them questions or lawyers ask them questions is say, I try not to do things that cause me pain. But in life, we're all in situations where we have to do things if no one else is around. And when I do it, I pay for it later. I have to go in the house, I have to lie down, I have to take medication, whatever it is. So that way you can't be impeached and you can't be shown not to be credible. And credibility, again, is one of the keys to what we're talking about.
So now we've got the case signed up. You've talked about some of the information necessary. Let's talk about beginning the case, and how do you prepare for that?
You need a plan. If you don't have a plan about where this case is going, then you shouldn't take the case. And the plan includes many things. Number one, I can never understand why lawyers have cases sitting in their files cabinets for 3, 4, and 5 years without working on them. Cases are inventory. Inventory is money. If you have a case sitting there you're not working on, you're not making money, the client's suffering, and it's a poor economic decision. We try to get a case in, and we try to get that case resolved, depending on the case, within 6 to 18 months. That clients are happy, my cash flow is happy, my banker's happy, my employees are happy, and it gives us a chance to really focus on the cases that are before us. But I need a plan to do that. I need to understand what medical care and attention this person needs. I need to make a decision as to whether or not I'm going to put the case into suit immediately, or I'm going to try to negotiate the case beforehand. And I base that factor on who the insurance company is, what the liability aspect is like, and how badly my client's hurt. Do I think that an insurance company is voluntarily going to pay fair value in this case, or am I going to have to litigate it? If I'm going to have to litigate it and have them do discovery, I may as well get that lawsuit filed fairly quickly. But I'm not going to file that lawsuit until I do a few things. Number one, I'm going to make sure I've got the initial medical reports. My client went to a hospital emergency room. I want to see the history that my client gave. I want to make sure that history is consistent with what they told me. If there was an accident, I want to see the crash report. I want to see if there are any independent witnesses. I want to get an investigator out to talk to those witnesses. I want to know what they're going to say. I want to show them pictures of the intersection, if it's an intersection, or pictures of the property where this accident happened, and have them point out to me exactly what went on. I may want to take their statement, either in writing or with a court reporter under oath, so that I've tied them down to their story. I want to do as much as possible, as quickly as possible, about finding out about this accident and also getting my clients records that existed prior to this accident. I want to know if they've been in prior litigation. I want to know if they've been arrested. I want to know if they've been in jail. I need to know everything about my client. I need to be able to represent them as best I can. If I file suit, I want to make a determination as to what causes of action I'm going to file suit for, who my defendants are. Sometimes you're not sure of every defendant in a case, and you need to be careful when you file suit in those cases, because you don't want to subject your client to 2 depositions or 2 examinations under oath. So we're cautious when we file suit to make sure that before we have our client examined by anybody, we're comfortable that everybody who should be in that case is in that case. Even if we need to amend our complaint, add other parties, we don't want our client going to 2 examinations under oath, physical examinations by defense lawyers or things of that nature. It's a process. We need to decide, do we need a voc rehab expert? Is our client losing wages? But more importantly, is his injury going to cause that client to suffer a loss of earning capacity in the future? Let me give you an example. I represent a doctor who has a severe neck injury. He's a surgeon. He could still operate, but he's starting to lose feeling in his hand. And that's a no-no for a surgeon. If he can't feel the instruments, if he can't suture someone, he's no longer going to be able to operate. He may be able to practice medicine, but he's going to lose a very important aspect of his practice and his income in not being able to perform surgery. I need to say, look, he hasn't lost any income this month or this year, but I know he's only 45 years old. He's going to have to stop working or performing surgery this much earlier. He's got a tremendous loss of earning capacity in the future. We have to anticipate that. We've got to get him examined by a voc rehabilitation expert who's going to assess that. We need a doctor who's going to say, yes, because of this injury, Dr. Smith is going to have to stop working earlier. And it doesn't only work with doctors. It can work with a truck driver. It can work with a laborer, a teacher, anyone. What down the road is going to happen to them that's going to require them to need extra money? Will they need to have household help as they get older because they're not able to do certain things that a normal person who's 65 would be able to do? You need to anticipate that. You need to start planning for that. And that goes back to understanding their injuries, understanding their lifestyles. Ask these people what their lifestyles are like, what they enjoy doing, what hobbies they have. Many people, for example, love gardening. Well, if they can't garden anymore and they've got to hire someone to do that, that's an expense. That's certainly compensable. So things of that nature are important. You need to start looking at that from the beginning. Case.
Now, you also talked about before, when you begin the case, you prepare as if you're going to go to trial.
Right. Our reputation is such that when an insurance company sees our firm name, they know either they're going to pay us fair value on the case or we're going to try the case. And that means spending money and doing the work that I talked about, hiring the experts. And I want to talk a little bit about experts. Experts are unfortunately a creation of trial lawyers and the court system, but they're necessary at this point. In order to get certain issues with regard to negligence and damages before a jury, either a doctor or an expert's got to come in and testify that they have an opinion, and their opinion is that either this was a dangerous condition or this condition is related to this accident or whatever else. You want to vet your experts. You want to make sure your experts could stand up to a Daubert challenge, a Fry challenge, a challenge as to whether or not their opinions are scientifically accepted or they're just out there. I can't tell you how many times that I've had defense expert witnesses' testimony struck because they weren't credible. And what I've done in those cases is I've asked the judge to allow me to voir dire the witness, and I go through their opinions. And more often than not, the judge has struck those witnesses from testifying, which changes the whole dynamics of the case. You need to do the same thing with your own witnesses. You need to meet with them, your experts. You need to explain your theory of the case, but more importantly, you need to hear what their theory of the case is. They're the experts. I don't profess to understand everything about metallurgy, accident reconstruction, aircraft design, maintenance, or things of that nature, human factors. I know a little. I know enough to be dangerous, and that's you have to be careful about that, because you want to try to direct the expert, but at the same time you want to listen to what the expert has to say. They may have a whole feeling about what the problem is that you never thought about, or their opinions may be so far-fetched that you don't think a judge would ever buy them or a jury would ever buy them. Then it's time to get another expert, or say to yourself, you know what, this case is going nowhere. I need to get out of it before it gets too late. And call your client in and tell them the truth. I've had your case investigated by some experts. We can't come up with a good theory as to liability in this case. I'm really sorry. I don't want to disappoint you, take you down the primrose path. And maybe it's time for you to look for another lawyer to see if you could come up with someone else. I've tried everything I can. Talk to other lawyers in the community. You know, the search engines today are terrific. You could go on there and get information about almost anything. And most of the trial lawyers associations have exchange sites where lawyers go on there and post questions and problems. I have this kind of case. What does anybody think? Does anybody know an expert in this field? And lawyers will respond and help you. And it's important to have that kind of communication. And it's also important to have a local mentor, someone in your community who has experience that you could call upon. And most lawyers will help without, taking over your case or stealing it or anything like that. They'll give you advice and help you along. It's important to talk to other professionals and to find out what's going on.
So I guess that answers the question for our audience. And how do you find some of these experts? One of the best ways to find it is through your associations, lists, and directories that may have them. Are there any other ways other than that you have had good experience with in finding experts? And also, do you negotiate the experts' fees with the experts, or do you just take them face value?
Well, I don't like hiring experts who belong to these companies that profess to find you an expert in 100 different fields. I don't think they hold up well under cross-examination. What I do like to do is I like to look at cases that have gone to court or cases that have settled that have been reported in different trial lawyer magazines or verdict reporters or things of that nature, and see who the various experts have been in those cases, and talk to the lawyers who hired them and see how they felt about those experts if it's someone I haven't used before. I think that works much better than looking in the back of a trial lawyer magazine and reading somebody's ad, which is going to be thrown up in their face at a deposition. I want to look at their CV very carefully, and today you can go online and pretty much get any doctor or any expert's CV. I want to make sure that their qualifications are great, that they're board certified, that they're licensed, that they're actively practicing, that they possibly have some teaching experience. I want to look at the titles of the articles and publications that they participated in and see if they've ever lectured or written about the exact topic we're talking about. I want to look at textbooks. If I'm talking about an issue in pathology and it's a very limited issue, let's say a sarcoma, and the diagnosis of what a sarcoma is in a particular patient is a question as to a patient was properly diagnosed or misdiagnosed, I want to talk to the guys who wrote the textbook on diagnosing sarcomas, and I'll call them. I'll buy their textbook, or I'll go online and I'll look at their textbook and I'll call the authors and I'll say, "Hi, I'm Stuart Greenberg. I have got this case. I understand you wrote this textbook. Do you have a few minutes to talk to me about it? And I'm thinking about retaining you, but I wanted to get some feel for you." And it's a really fine way of getting an expert. As far as their fees are concerned, we sign fee agreements all the time, and to be honest with you, I don't negotiate with experts. I believe that if an expert feels that this is his value, you either accept it and afford to pay it, or you don't. I never like to have an unhappy expert, and I think if you start negotiating with their fees, if their fees are in line with everybody else, then there's nothing to negotiate. If their fees are higher but their qualifications are that much better, there's nothing to negotiate. Or move on to someone else if you can't afford it. You don't want an unhappy expert.
Are there any usual and customary fees for expert testimony? Or is that all based on the expert themselves?
It varies, and I've seen all sorts of things. But at the same time, don't allow yourself to be taken in by the defense experts. I had this case in New York years ago where I represented a young man who fell down the elevator shaft of the Chrysler building and had sustained a closed head injury. And I had 7 defense attorneys on the other side because I sued a bunch of different entities. And I got on a flight and I went to New York, and as I got there, this was before cell phones. I'm dating myself. And there was a page for me at LaGuardia Airport. And on the phone was my secretary telling me that the defense psychiatrist had asked for $3,000 for my deposition of him, which was scheduled to last 2 hours. And I thought that was outrageous. So I called the defense lawyers and I said, let's get the federal magistrate on the phone because I'm not paying this fee. I flew all the way up here, and this is, a last-minute ambush. So the magistrate said and ordered right then and there that the doctor will submit to his deposition, and he'll determine a fair fee later on. So I started to take the doctor's deposition, and I said, Doctor, let me ask you a question. When you get a new patient, how much time do you spend with the patient? He tells me 45 minutes. And what do you charge for that consultation? He says, $285. I said, and you see a patient in follow-up. How long is the follow-up? 45 minutes. And what do you charge for that follow-up? $225. Well, doctor, then why are you charging me $1,500 an hour for your time? Well, the judge gave him $285 an hour. So there are ways around it. Most times what we'll do is, if my orthopedic surgeon's $500 an hour and the defense orthopedic surgeon's $800 an hour, I'll say to the defense lawyer, look, let's pay them both $500 an hour and tell him to reduce his rate. Sometimes I'll file a motion with the court, but I'll always pay my expert what he's asking for.
Let's talk about evidence a little bit. You obviously have to gather evidence before the case to build up the case. Who does the evidence gathering in your offices? Do you leave that to investigators? Do you leave that to your staff? Do you personally go and do it?
It's a combination of all the above. The first thing that we do, honestly, is we each have a camera. I bought every staff member a camera. And the first thing we do is we take a picture of our client. And we put it in the file so that way we know what they look like. Let's say I send my associate down to meet the client at a doctor's office or a hearing. He's going to know what that client looks like. Secondly, we take pictures if they come in and they have an obvious injury or wound. We take pictures of their car. We send an investigator out to the property. But more times than not, I myself or one of the lawyers assigned to the case will actually visit the scene of the accident. Let me tell you why that's important. Because you don't get a feel for how something happened until you actually see the location. Because you may get a feel for exactly the dynamics of what happened, how someone reacted the way they did because you see it, because you're there, because it's live. One of the things I ask a prospective jury is, how many of you have been in an accident? Well, a lot of them raise their hands. But then I say to them, tell me about it. How quickly did it happen? And everybody says, oh, it was a split second. I never saw it coming. I didn't have a chance to look at the other car. I didn't even know where he was coming from. I didn't know their speed. These are the kind of things that are important because defense lawyers are going to start harping on your client. Well, did you see the other car before it hit you? How fast was he coming? Did you know that he was going to hit you? Before you tripped, did you see the piece of steel sticking out of the ground? And you want to go ahead and try to prepare for all those things before you even begin to put together your case plan. So we ask for shoes for people who've tripped and fallen. We go out to sites and visit them where there's a car accident, if there's an intersection. We actually have warehouses with cars that have been severely damaged in accidents where we maintain the car. For example, we do a lot of trucking accident cases. And unfortunately, in those cases, cars sustain catastrophic damages. We take those cars, put them on a flatbed, put them in a warehouse, and we maintain them. And when we get involved in the lawsuit, the defense says, well, where's the car? I said, we got it. They looked at me like, we're crazy. I said, have your expert come look at it. It's not a problem. There's also something very interesting. many vehicles now, especially trucks, have black boxes or what's called event data recorders. And these devices, which are found in some General Motors cars and many trucks, they record the speed, braking, acceleration, all sorts of things which happen right before a particular event, which are amazing to get information from. I had a case a few years ago. I represented the family of a lady whose car broke down on an interstate, and her car broke down in the third lane of 4 lanes. It was at night. She had walked over to the safety zone and was struck by a Escalade, Cadillac Escalade, in the safety zone, knocked right out of her shoes and killed, left 2 young sons. The driver of the Escalade was the general manager of the Cadillac dealership, and his testimony was, well, I was doing 55 miles an hour, which was the speed limit. Her car was stopped with its lights off in the middle of the road. I had to swerve and I had to hit her. We downloaded the event data recorder from that car because the day after we got the case, we sent the defendant a letter saying, we want you to maintain this car until we have an opportunity to examine it, which is what we do in a lot of cases. We ask them to maintain their surveillance films, if there are surveillance cameras, or event data recorders, or the vehicles, or whatever else. When our expert downloaded, actually when the General Motors expert downloaded the speed, it showed that the driver was doing 79 miles an hour, which was 24 miles an hour over the speed limit, showing he lied in his statement to the police, he lied in his deposition, and that case settled for a significant sum of money. So it's all part of getting done early on in a case what you need to do.
So you've gone down, you've witnessed, you've gone to the location of the accident. Now let's talk about speaking to the witnesses. You know, who goes out and speaks to the witnesses? How do you do your gathering of witnesses? What's your process?
Well, it depends. Sometimes one of the lawyers will do it, accompanied by an investigator. Sometimes an investigator will do it, depending upon the schedule of lawyers. I'd like to have an investigator there because it's someone who is not an employee of my firm, even though we have an in-house investigator who does a lot of the investigation. Statements I like taken by an outsider who, if there is a problem, could come in and testify as to, I worked for myself, I went out there, I took a statement, I swore them in under oath, this is what they said. And I also like to meet the witnesses because I want to size them up. I want to see what kind of appearance they make, how well spoken they are, because you need to know the jurisdiction you're in. For example, our practice primarily is in South Florida, but we have cases all over the state of Florida and in other jurisdictions. And there are certain types of witnesses which play better in Miami and may not play as well in Jacksonville, or may play better in New York City and not as good in Tampa. So I want to know who the witnesses are that we're going to call. I want to see, once I pick a jury in a case, who's going to sit well with the jury, who's going to connect. Do I want somebody who I have to have testify through an interpreter? Or do I want somebody who is going to testify in English? Or do I want both? And that will also make it easier for me to determine who the experts are. I once found an expert in the south of France who was an expert on what happens to motorcycle gasoline tanks which are full and when they're punctured, and what happens to the spray pattern. And believe it or not, I had a case where that was the issue, where a man traumatically lost his leg, and based upon this expert in South France testimony, we settled the case for a significant sum of money. So it really, you need to find, there's so many people out there with so much expertise that you want to try somebody who's really on point. And the same thing with witnesses. Witness testimony is notoriously not great. How can I say this? There have been studies done where professors are in classrooms, and there'll be 100 students, and somebody will run in, shoot the professor, he'll fall to the floor, they'll run out. And everybody's shocked. And a few seconds later, the professor will get up and say, okay, now write down everything you remember about seeing about that person. And you'll get 100 different descriptions of the person who shot the professor, what he looked like, how he acted, what he was wearing, because people perceive things differently. And what you need to do, in my belief, is you need to try to lock the testimony in with the scientific facts. And to do that, you need to have the pictures of where the person fell, the physical evidence, the expert telling you how it happened, and talk to the witness and try to see if their story jives with the facts. Almost like a CSI type situation. CSI, by the way, doesn't work. And it's created a tremendous amount of problems for lawyers because everybody expects DNA evidence, forensic evidence to be there, and it's not always there. And it doesn't come in an episode in 1 hour. And it's made our job as lawyers that much more difficult.
So tell me, you talked a little bit about having an in-house investigator or an independent investigator. One is, how do you go about finding your investigators, and when do you make that decision that you're better off having your in-house person do it versus an independent investigator?
My in-house investigator gets on the case from the beginning. And he'll go out there and take the pictures of the car, the intersection, things of that nature. The outside investigator is if I need to talk to witnesses or listed on a police report or some other type of report, and I'll bring them in. And the only best way to find them is speak to other trial lawyers, get recommendations, ask them to see some of their work, personally interview them, and develop a relationship with them.
Now tell me also about meeting with the police and rescue personnel that are at the scene.
Some jurisdictions permit pre-suit meetings and others don't. You've got to find out what the policy is in the jurisdiction where the accident occurred. I like to go ahead and meet with the police officers and talk to them and develop a rapport with them. I'd like to try to speak to the paramedics because paramedics and police officers answer dozens of calls every day. And you want to distinguish or have them create some sort of memory for your case, so when it comes time for them to give testimony, they'll remember the facts of your case. So if you can, show them the photographs of the scene of the accident, show them the photographs of your client, the vehicles involved, show them their reports, and see what you could get from them as far as their recollection is concerned. Oftentimes the reports are computer generated. They don't state exactly 100% of what happens, but their recall, if you get to them early enough, is important.
Now, you touched on managing the case and meeting with the treating physician, and especially identifying the physicians that you're going to work best with. Can you talk a little bit about expert testimony, economists,
Sure.
Determining what the loss as far as wages are going to go also?
You need to talk to someone and understand what your client does for a living and what their educational background is to understand what the economic loss is to your client or to their family. Some people are underemployed. Some people have jobs that they're working on at the time of the accident that are temporary, short-term, but don't really live up to what they're qualified to do. So you need to understand what their qualifications are. And that comes from talking to family members, talking to the client, and speaking with a vocational rehabilitation expert. You'll also need to hire an economist who could project what their future losses are and put that into terms of present money value, because that's what you're, in most jurisdictions, entitled to bring up, what the losses are related to today's dollars. Those are really hard concepts for juries to understand. And what I have found today is that juries like technology. So we use a lot of PowerPoints in our cases. And we use PowerPoints for mediation purposes, and we use PowerPoint for trial purposes. We also, believe it or not, like to use blackboards. And I love to have experts come down in front of a jury with chalk in hand on a blackboard and draw or write a little bit. And I'll tell you why. Because we all went to school. And how did we learn in school? We learned one of two ways. If you're a little bit older, you'll learn by the teacher writing on a blackboard, or today you learn by a computer. So if you're getting the feeling that the person talking to you is teaching you like a teacher did, and they're coming down to your level, and they're using an Elmo, or they're using a laptop, or they're using a computer, or they're using a blackboard, you're more apt to listen and believe what they say than if they're sitting on a witness stand just telling you things. And technology plays an important role. We order models, for example, in many cases. If I've got a spine injury, I have models of spines in my office showing the nerves, showing the discs, showing the vertebrae. If you have an eye injury, I've got a model of an eye, a brain injury, a model of a brain, because it gives people a three-dimensional way to see something. And if there's a surgery performed, sometimes, ask the doctors, they may videotape it. There are a lot of arthroscopic procedures that are filmed. And it's very impressive to show a jury, hey, here's the surgery of this client's knee. And the doctor will explain exactly what it is. Or if you can't have that client's knee, there are films out there available that'll show you what an arthroscopic knee procedure looks like, or a total joint looks like. I've handled cases where we've had shoulder replacements, knee replacements, where I've actually purchased prosthetic devices that match the ones that have been implanted in my clients. And when you hand that to a juror, and they feel the weight of an artificial shoulder, or the bulk of an artificial knee, and the doctor gets down and explains how it works and how it has a certain life expectancy, and because of the client's age, that's going to have to be revised in 10 or 12 years, and what the costs involved are, you've just exponentially increased the value of your case.
So now you've been managing the case. Let's talk a little bit about making demands and how to make them effectively.
Presentation, again, is everything. We've gone ahead and purchased a binding system for our office where our demands, once they're put together, are bound into a package or packages. And what we've done is not only created a narrative, or you do create a narrative for each one, and we try to keep it fairly short because nobody's going to read a lot. But we put in there photographs of the client, the vehicle, the place they got hurt. We now order MRIs or other scans on discs and actually print out those segments of the MRIs or scans and put them into our settlement package, so that when the adjuster gets this package, it's going to be completely different from the other 99 packages he or she has on their desk, which are pieces of paper with a staple at the end. Ours is bound, ours is colored, ours is professional looking. And they're going to look at that and say, you know, I've got 100 cases. I've got to get rid of some of these by settlement, some are going to go to trial. Greenberg's firm's going to annoy me because look at the work they're doing. I don't want to have to live with this case forever. Let me look at his demand more seriously and give it some consideration and try to get it resolved. And we have found that that works. At the same time, if it doesn't work and we have to go to trial or mediation or whatever else, we just keep creating that image that we're going to spend every dollar. We're going to have the PowerPoint presentation in mediation. We're going to have the blow-ups. We're going to have the medical illustrations. We're going to have the models. And, you know, much more often than not, 98% of the time, the defense will say, okay, we're going to get into the range of reasonable, we're going to make a fair offer, and we're going to try to get the case resolved.
What's your time frame on getting the demand letter out to the insurance companies or to the companies that have liability once you take on and retain that case?
It depends upon the case. If it's a very small policy and a catastrophic injury, immediately. If it's a very large policy and it's an injury that's going to take time to manifest itself, such as a closed head injury, where doctors will tell you that the person will plateau for a year or 18 months, you may have to wait the year or 18 months. It really depends upon each individual case. But as soon as a doctor says, a client said maximum medical improvement, we're ready to rock and roll.
And it's interesting because I know you probably run into it also where a lot of patients feel that they need, and your clients feel that they need to talk to you every day about a case. Can you explain how you handle that communication with your client?
With kid gloves and lovingly. And you talk to them and you explain to them that their case is moving, but you explain that things don't change every day or every hour, that you're happy to answer their questions, but in order for you to properly service them and your other clients, they need to give you a little bit of time and a little bit of space. And then you pick up a phone and you call them maybe once a week so that they feel you're invested in their case. And they won't pick up the phone and call you as often if they see that you are actively moving forward and caring about them. The biggest problem, I think, lawyers react. You really need to do is be proactive. And if you're proactive to your clients, to the defense lawyers, to the adjusters, you're going to get a much better reception and a much better result.
And not only that, you'll probably build a much bigger practice by being proactive.
Absolutely, because let's face it, there's tens of thousands of lawyers out there vying for cases. You want to separate yourself. And to do that, you're in the service industry. Service your clients, it'll come back to you.
It's interesting because I had an attorney tell me just the other day how he had a client that was a prior client call him on a regular basis. And he was one of those annoying clients that he just didn't want to pick up the phone for. And finally, he was out picking up groceries. He saw the client out at the grocery store, and the client indicated to him that he was actually referring him a case, and it was a bus accident, and all the people went to another attorney because he couldn't get in touch with his guy in time.
It's one of the biggest nightmares I never want to face. I mean, some of my largest cases have come from favors or small cases I've handled for other people, but have made them happy and been receptive. So when a client calls, return the call or have somebody else do it. Find out what it's about. It may be that bus case. It may be some other important matter, or it may not be. But we try to tell our clients, look, if you have any legal issue at all or any concerns, call us. If it's something we can't handle, we'll help you get to someone who could help you. That's one way to build your practice, to maintain client relationships, and also to develop a referral source in the field, which we'll talk about a little later.
Great.
The CLE code for this disc is PIE 2783. This program continues on the next disc.